Pregnancy discrimination is one of the most common employment law claims I see as an employment lawyer. But pregnancy discrimination can come in many different forms, like disparate treatment, hostile work environment, retaliation, and failure to reasonably accommodate. In this video, I'm going to go over each of those different forms of pregnancy discrimination, what employers use as their defenses against pregnancy discrimination, and what you get if you win your claim of pregnancy discrimination. So stick around. Nothing in this video is legal advice. Talk to a lawyer about your specific situation to get legal advice. To understand the laws against pregnancy discrimination, we should first look at the law. And the law against pregnancy discrimination can be found in Title VII of the Civil Rights Act. Many states also have their own laws against pregnancy discrimination too, but those laws are usually based on those same protections from Title VII. So in this video, we'll just be looking at Title VII. And Title VII says the following: "It shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise discriminate against any individual with respect to his or her compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin." Now, the important part about Title VII for this video is that it prohibits employers from discriminating against employees on the basis of that employee's sex. And because an employee's ability to get pregnant is so closely associated with that employee's sex, to discriminate against an employee because of their pregnancy is to discriminate against that employee based on sex. So pregnancy discrimination is a form of sex discrimination, which violates Title VII and its associated anti-discrimination laws. But pregnancy discrimination can take many different forms. So let's look at the different ways that pregnancy discrimination can occur in the workplace. The most common and obvious form of pregnancy discrimination is called disparate treatment. And disparate treatment is what people are usually talking about when they say discrimination. It basically means that the employer is treating you differently because of your protected class. And being pregnant is a protected class. To succeed on a claim of disparate treatment pregnancy discrimination, you'll have to prove a few things. First, you will have to show that you were in the protected class of pregnant workers. So you'll have to show that you were pregnant or potentially pregnant, you are currently pregnant or potentially pregnant, or that you have a medical condition associated with pregnancy. Second, you'll have to show that your employer knew about your pregnancy, which is not always so obvious. But if you told your managers about your pregnancy, or you were showing, then that's probably enough to show that they knew. Third, you'll have to show that the employer took some adverse action against you, like firing you or demoting you. And finally, you'll have to show that the employer was motivated by your pregnancy status when it took that adverse action. So let's talk about some examples of disparate treatment pregnancy discrimination, because I see this claim happen a lot. 1, refusing to hire or promote because of pregnancy and the negative assumptions employers have about having to accommodate pregnant workers. 2, firing a pregnant worker to avoid having to pay her during her pregnancy leave. 3, firing a pregnant worker after she returns from her pregnancy leave because of some negative attitude about her taking that leave. 4, making any adverse employment decisions about a pregnant worker based on negative stereotypes or assumptions about the responsibilities of childbirth and afterbirth caregiving. The next claim is called hostile work environment. And this one is less common for pregnant workers, but it still happens. Hostile work environment pregnancy discrimination occurs when a pregnant worker is subjected to persistent and unwelcome words or conduct about their pregnancy. So it's basically when you are being harassed by anyone at work because of your pregnancy. Now, to succeed on a claim of hostile work environment pregnancy discrimination, you will have to prove a few things. First, that there was language or conduct concerning your pregnancy. Second, that the language or conduct was unwelcome, meaning that you found it offensive and that you didn't incite the behavior. Third, that language or conduct was so offensive or persistent that it affected your ability to do your job. And finally, you'll have to show that your employer is liable for the harassment. Now, if a manager or corporate officer is doing the harassing, then the company is then automatically liable for that harassment. But if the harasser is a coworker or non-managerial staff, you have to show that the company knew or should have known about the harassment, maybe because you reported it to HR, and that the company failed to remedy the situation. The third claim is retaliation based on protected activity related to pregnancy. Pregnancy retaliation occurs when a pregnant worker engages in a protected activity and their employer takes an adverse action against them in retaliation for engaging in that protected activity. So you'll have to prove a few things. First, that you engaged in protected activity. Second, that your employer took an adverse action against you, like firing you or demoting you. And third, that your employer was motivated by your protected activity when it took that adverse action. Protected activities for pregnant workers include things like requesting or taking pregnancy leave, or taking leave for a disability associated with their pregnancy, or reporting discrimination or harassment on the basis of the pregnancy. When you do any of those things and your employer takes some adverse action against you in retaliation for doing it, that's a form of pregnancy discrimination called retaliation. The final pregnancy discrimination claim I will be talking about here is failure to reasonably accommodate a pregnant worker. Now, this form of pregnancy discrimination isn't enforceable to the same extent in all jurisdictions. So I'll just be talking about Washington State's law here because I'm licensed in Washington State. But many other states have similar laws. In Washington State, employers with 15 or more employees have a duty to make reasonable accommodations for pregnant workers. These accommodations include things like flexible scheduling, modified job duties, frequent or longer restroom breaks, modifying food or drink policies, providing seating when the job requires the worker to stand, providing assistance or light duty responsibilities for manual labor, providing time and location to express breast milk, along with other accommodations as long as the accommodation does not create an undue hardship on the employer. And we'll talk more about undue hardship in the next section. But when an employer fails to provide one of these accommodations or subjects the pregnant worker to adverse action for asking for one of these accommodations, the employer is then in violation of the law. Now, employers will very rarely, if ever, admit to discriminating against a pregnant worker. So instead, they come up with defenses. And the two most common defenses that employers will use against pregnancy discrimination are as follows. First, legitimate non-discriminatory reasons, or LNDR for short. And two, undue hardship. First, in almost every discrimination case, the employer will come up with a legitimate non-discriminatory reason for their actions. That means that the employer will try to argue that when it took that adverse action against the pregnant worker, that it wasn't motivated by the worker's pregnancy, but rather that the employer was motivated by something else unrelated to the worker's pregnancy. The most common LNDRs, which I see in almost every case, are when employers claim that they terminated or demoted the pregnant worker because of her poor work performance, or the employer was just following a disciplinary policy because of the pregnant worker's improper conduct. Then, in order to win the claim, the pregnant worker has the burden of proving that the employer is lying about this legitimate non-discriminatory reason, and that it was in fact motivated by the worker's pregnancy. The next defense is undue hardship. And for this defense, the employer is basically stating that it can't afford to accommodate the pregnant worker. But to succeed on this defense, the employer has to show that the pregnant worker's accommodation would be significantly difficult or too expensive for the employer to provide. And this is a pretty narrow exception for pregnancy discrimination. But generally, employers aren't required to promote an employee who isn't qualified for promotion, to discharge one employee to accommodate another, or to transfer an employee with more seniority than the pregnant worker. When you win your claim of pregnancy discrimination, the court awards you money to compensate you for what your employer put you through. This money is called your damages. And the damages for pregnancy discrimination are a little different between state and federal laws. But generally, there are two primary categories of damages for pregnancy discrimination, and you can collect both. First is lost wages, and second is emotional distress. Lost wages are the wages you would have been paid had you not suffered discrimination. For instance, if you were fired for being pregnant, how long were you out of work and how long do you think you will continue to be out of work? Did you get a new job that pays less? The amount of wages that you would have gotten paid had you remained in your position, or the difference in pay going forward, are your lost wages. Emotional distress is compensation for the emotional harm you had to endure because of the discrimination. For instance, have you lost enjoyment in life? Were you humiliated or embarrassed? Did you suffer from fear or anxiety as a result of the discrimination? And that's just a broad overview of emotional distress. Emotional distress damages will vary drastically from case to case, and they will depend on the facts and circumstances of your case and what your employer put you through. So there you have it. The bottom line is that the laws against pregnancy discrimination prohibit employers from treating you differently because of your pregnancy. If your employer is treating you differently because of your pregnancy, talk to a lawyer. If you're in Washington State, feel free to reach out to my firm. And if you like this video, hit that like button and subscribe to my channel. I make videos about the laws that protect workers. The more we hold employers accountable for their wrongdoing, the more we protect other workers. That's all for me this week. See you next time.